Hello, my name is Rocco Strangio, and I'm the host of the Law, AI, and Money podcast. I bring on attorneys, engineers, and entrepreneurs to unravel the world of AI and to discuss how it'll affect the legal profession. Today, I'm talking with Mark Bartholomew, a University at Buffalo School of Law professor and author. Mark obtained his BA from Cornell University and his JD from Yale Law School. After clerking for the Ninth Circuit, Mark worked as an in-house legal counsel and as a litigator. Mark has also written multiple publications on intellectual property and artificial intelligence. In our conversation, Mark and I talked through President Biden's recent AI executive order. We talked through the strikes and lawsuits that have emerged as a result of this new technology, and we also talk about Mark's recent publication, A Right to Be Left Dead. Thank you for joining our conversation. Hey, Professor, how you doing?
I'm good. Nice to see you, Rocco.
It's nice to see you as always. I want to first thank you for coming on. I know you're a busy guy, and I really appreciate your expertise on this space. Not many people know about AI, especially as it intersects with the law, and I feel like you're one of the few people, and from my experience at UB, one of the best professors I've ever had.
So that's nice of you.
I'm very grateful for you for being on. So thank you.
Happy to do it. When I get a good student who makes a request, I'm always happy to help out.
Professor, before we get into the actual technology and your article, A Right to Be Left Dead, could you explain what's going on with the Hollywood actors strike? I feel like that sets the stage a little bit for what's going on here.
Yeah, sure. So it's recently been resolved, but the strike boiled down to a couple issues. Maybe the main one was just about money. How do we compensate actors in a new regime where most of us are getting our entertainment through streaming platforms instead of traditional, seeing movies in theaters, watching things over terrestrial television. So a lot of it was about that. But the part I was particularly interested in was also an important part was how should the actors be compensated when a synthetic recreation of them is used to populate a new film or a new television show? And the fear is that AI would be used to kind of just create a new cast for new movies without ever having to pay the actors. So recently, they brokered a deal where some compensation will be provided, and probably most importantly, consent has to be obtained, informed consent before AI can be used to take someone who was in one movie, generate a new version of them in a new movie without paying them.
Wow. And that's incredible. That ties into our next talking point, and that's the piece you wrote on called "The Right to Be Left Dead." Incredible piece. I had the chance to read it last week. What is the newly forming right, a right to be left dead, and how is it affecting the legal landscape currently?
Yeah, so a right to be left dead is my umbrella term for using AI to make use of people after they're already passed on. So Amazon and Microsoft are introducing these after death chatbots. So they take all the things you've said or put on social media, and they can use that to speak in your voice in the way you might have communicated while you're alive after you're dead. There's use of digital recreations of people in commercials, like famous celebrities, and potentially ones after they've died. And as we just mentioned, entertainment, populating new films or new television shows with actors and putting them in scenes they never appeared in before. And so this is attracting some attention in New York State, also in the U.S. Senate. There's been some hearings on this. Mm-hmm. And the point of the article is to suggest we should think about this in a pretty logical way. Like, I think there are reasons to sympathize with people not wanting their recreations of themselves via AI without their permission. Yeah. But we need to think about why we might intuitively want to block that kind of behavior and what the guardrail should be for when businesses can use this technology and when they shouldn't be able to use this technology. And just one more note, as I'm sure you remember from law school, there's a famous article a century ago called A Right to be Left Alone. And I like this article because it's one of the rare occasions where law professors actually definitely change the law in a very important way, almost instantaneously. And so this famous Right to be Left Alone article generated what our current privacy laws are. And so A Right to be Left Dead is a nod to that.
Very interesting. I think, well, hopefully this piece has the ability to sort of trailblaze some legislation and regulation in the space. And I know during our law school classes, we would go through and everybody would kind of give their opinion on what they think. Me personally, I almost think intuitively somebody's NIL, let's say, for example, would be more valuable after they're dead than when they're alive because it goes indefinitely. And it gives so much power to the people who hold that right.
Yeah, it's already big business. There are these corporations that just have a stable of rights of dead celebrities. So think Marilyn Monroe, James Dean, and this is billion-dollar corporations. In some circumstances, people are worth a lot more money after they die for whatever reason. So you're definitely right. There's money to be made here. What I try to venture in the article is the law already thinks a lot about, well, when should someone's rights continue after they die? When do those rights get extinguished? So, for example, your right against defamation, right? That continues while you're alive, but we say, well, people can't really be embarrassed after they die, so there's no right against defamation after someone has passed on. On the other hand, trademark law says, what are we worried about with trademark law? We want to protect people from being confused, consumers. So in lots of situations, a case involving Princess Diana, Diana's estate for one of them, we say it makes sense for trademark law to continue even after the celebrity has died. And so I'd like to think about this right to be left dead in a way that analyzes why do we want it? If it's to prevent people from being embarrassed, maybe it shouldn't continue after death. But if it's about protecting consumers or other reasons we might have for introducing a new law, then we should think about maybe it should continue after death and how long should it continue after death. And so that's my goal, maybe to intervene before lawmakers create a right, that's not tailored to the specific reasons why we want to have a right to be left dead.
That's awesome, Professor. A lot of attorneys hopefully are going to listen into this podcast episode, and hopefully this spurs that movement. Right now, as everybody knows, one of the most influential AI platforms is OpenAI. And so they created ChatGPT. Do you know the contents of why they're being sued for copyright currently? And in your opinion, how viable are those claims against OpenAI?
Yeah, so it boils down to two things. One is the training data. So OpenAI relied on just a vast swath of training data, just combed the web for. And one allegation is that, well, this training data relied on copyrighted content, massive amounts of copyrighted content. And so the question is, does reproducing that copyrighted content just to train the AI, does that violate copyright law? I would say it's not a slam dunk, but overall, OpenAI has the better argument there. They can argue fair use. There are older cases about decompiling computer code for one video game platform system to develop new games for a new system. And the law has held, well, if you're just using it internally to develop something new and the end product doesn't violate copyright, we can see why there's a good reason to at least internally in-house make these copies, and even if they're unauthorized. So I think the training data overall, I'd rather bet on OpenAI's side of things because I think they can argue fair use than the copyright holders. And then the second part of the allegations are about the output. Regardless of the training data, you can use OpenAI and other platforms now to create something that looks just like or sounds just like actual copyrighted content. If I go in there and I say, I want you to create, a version of SpongeBob SquarePants that's a Buffalo Bills fan, it will do that for me. And so the output, we might argue, violates the copyright in SpongeBob SquarePants, or we can think of other examples. And so then the question is, who's responsible for that infringing output? Some would say, well, it's just the person who typed the request. It's Rocco or it's Mark. They requested this thing. We can't hold OpenAI responsible. Others would say, well, maybe it's the platform that created this ability for people to make infringing content, and they should be held responsible. I think that's probably the more serious of the two claims.
Mm-hmm.
Right now, I'd probably bet more on OpenAI. Like, unless they had specific knowledge that someone was doing this, I think they get some general breathing space in the law because the law likes to foster new technologies. But it's definitely something that's not obvious just on the facts.
That's awesome. Super important which way it goes, though, Professor. Yeah. Because with all the new technologies coming out, not just ChatGPT, there's a whole host of other ones. There's the potential privacy concerns, concerns for copyright issues, and so we need to watch this space closely. I thought it would be a little bit more one-sided, to be honest, but I give deference to your expertise in this space.
Well, I'm cautious too, but yeah, I think you thought it'd be more one-sided on.
I just assumed, though, not using legal analysis.
Oh, yeah. Well, we'll see. I think if I had to guess, there's just so much at stake here. If you say you can't use this training set data, that changes the game right away. So my guess is there'll be some sort of settlement or agreement, but I don't know. We'll just have to stay tuned. It'll be fun to teach the actual case in a couple of years.
Yeah, that's awesome. Professor, President Biden recently introduced an executive order seeking to regulate labor standards, workplace equity, and a whole host of other issues as it relates to AI. Could you explain what some of those changes that President Biden introduced are and what they mean for the space?
Yeah, I think at this stage, because it's just an executive order, most of what it's doing is collecting data. There'll be a report. I think the Biden executive order is particularly worried about labor practices, kind of going back to what we started this conversation about and the concern about cutting out Hollywood actors out of jobs. Mm-hmm. There's a lot of worry, of course, about is AI going to replace us? Even in the legal field, there's some concern about that, which I know you've talked about on this podcast already. So I think that part of the goal here is just to collect information about that to make decisions going forward. Also, the idea, I think, is to start articulating some best practices from the Labor Department. If you're going to use AI to monitor your employees, for example, what's fair and what's not? If you're going to use AI to help make hiring determinations, what's okay and what isn't? How do you police for bias and that? So I think a lot of it's just going to be not binding, but articulating preferences, gaining information. But it might set the stage down the road for more concrete actions. I wouldn't think it's going to happen anytime now, given the way these things work, but we might see an AI bill in Congress before too long that would actually have rules one way or another on some of these things.
Mm-hmm. Okay. That's interesting. So we're just setting the stage. But, change has to come quickly. We know how fast this technology develops. We're on the brink of possibly creating an AGI, artificial general intelligence, that might become as sentient as humans themselves. So hopefully this starts some change. And there's a whole host of different technologies, not just artificial intelligence, but like other technologies that incorporate it that are also, need to be regulated. Like one of them I think about is Neuralink. I don't know if you ever heard about the brain interface technology that they're trying to implement. That combined with AI, I know one of the questions we talked about before was about whether maybe in the future, whether we would ever depose somebody's mind for trial. And I don't know, it just seems to me that there's so much technology coming out so quickly that there's really no room to hesitate on any regulation.
Right. It's hard because on the one hand, I think what you're saying is absolutely true. This thing is moving a lot faster than people envisioned just a few years ago, and there's real potential for harm in some situations. But on the other hand, courts and even lawmakers are always good at like figuring out where the technology is going to go, and you're nervous about making a rule that would stop things from proceeding in the best pathway forward for advances for society. So it's tricky, yeah. And I think that doing nothing isn't an option, but how we regulate this is going to be pretty important. On the on the on the brain interface stuff, I'm really interested in that stuff too. And it reminds me of the movie Minority Report and kind of predicting people's thoughts in the future. I mean, right now, I wouldn't worry so much about being compelled to have your head scanned. Uh, I think the Fifth Amendment would probably protect us from that. It'd be sort of testimonial evidence. But in civil matters, would we get to a stage not that far off from now where that would be possible? Maybe. I mean, these technologies are becoming more and more portable. So one kind of safeguard was just you can't really force somebody into an MRI machine against their will. But I've been reading more and more about portable things, including to the point where you might be able to kind of point, almost like a laser pointer at somebody and generate some of this data. And at that point, we're really going to have some concerns about revealing information about people they didn't want to be revealed. And just one thing I'll say, what I'm more worried about, even more than being compelled by legal actors, is people giving up this information for free. We're so conditioned to give up private information for discounts or to click on terms of service. And as this stuff gets more and more easily accessed, I can see there'll be a temptation. Well, if I want to use the best features of my, PlayStation 8, maybe I have to give them rights to see what's going on inside my head. And that's something I think we probably need to regulate before too long.
That is so true, Professor. We're so willing to give up our privacy for a marginal benefit, like you just mentioned, until there's a point where now everybody's becoming aware of how actually powerful AI is. And now all of a sudden, everybody's so hesitant to give stuff to ChatGPT when before it was like, oh, no problem. If it's going to do my homework for the night, yeah, they can give my social security number. It's no problem.
Right. And as human beings, we're bad at kind of evaluating the trade-offs between short-term gain and long-term consequences. I know I'm always tempted to do this all the time. Well, I just want to do it now, so I'll click and go ahead and give up this information. But as you said, as we know more about AI, the long-term consequences are becoming, I think, more resonant for people.
Yes, I completely agree, Professor. Professor, I just want to thank you for taking the time to come on. As we've seen during this conversation, you're very well versed in the space, in the field of law as in general. And so I really appreciate you coming on. I'm sure all the guests, listeners do as well. And, hopefully your piece, A Right to Be Left Dead, which everybody should go and read, spurs some sort of change in the space.
Well, thanks a lot. I'll just say, it's nice to communicate with you about what I see as a very important topic. And also, it's nice when one of my best IP students in the past is investigating these issues.
Thank you, Professor. All right. I'll talk to you soon.
All right. Bye.
Thank you.